case briefs, and so much more. LSData's got what you're looking for.
In September 1972, a fatal collision occurred in Liberty County, Texas, involving two heavy tank trucks. The plaintiffs, the widow, sons, and the owner of the truck that was hit by the second truck, alleged that chemical Leaman Tank Lines, the defendant, was responsible for the accident as their truck crossed over the centerline of the highway, causing the collision. After 3 jury trials, the district court granted a new trial on the grounds that the defendant introduced a surprise expert witness. The plaintiffs appealed this decision, but the majority opinion of the Court of Appeals ruled that the district court did not abuse its discretion. The case then shifted to focus on the awarding of interest to the plaintiffs and whether it should be given from the date of the original judgment or the new one. According to Texas Revised Statute Art. 5069 1.05, interest on compensation should only start accruing from the date of the new award, not the date of the original erroneous judgment. The United States Court of Appeals for the Fifth Circuit, hearing the case in 1982, ruled in favor of this principle and decided that the plaintiffs should receive interest from the new award date, not the first trial date. As a result, the district court's post-judgment interest award was reversed, and the case was remanded back to the lower court to enter the award from December 18, 1981.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.